Okay, folks, again, this is Doug Pinkham with Pinkham & Associates. We are a dedicated family law firm in Orange County, California. I'm helping you with the FL 341A. It is a supervised visitation order form. If the court ordered supervised visitations, or if you and your spouse, or you and the mom or the dad of the child are agreeing to supervised visitation, you're going to use this form. You're going to fill out this form, and it's going to get attached to any order or a judgment that you file. So, starting right at the top, put the names of the petitioner and the respondent. They never change. So whoever the petitioner is, put a petitioner. Whoever the respondent was in the original paperwork, that's the respondent. And then also put the case number on the top right. Okay, so right off the bat, this form gets serious. It says, okay, so one is evidence has been presented in support of a request that the contact of the petitioner or the respondent, whoever's going to have monitored visits, let's say it's the respondent, with the children may children be supervised based upon allegations of, and then whatever the reason was. There's a fear that the child will be abducted, physical abuse, drug abuse, neglect, sexual abuse, domestic violence, whatever it may be, alcohol abuse, drug abuse. So if there's something other and it was spelled out in a trial or a hearing, or if you guys agree to it, you mark other and then spell out what that other issue is. Mark other and then actually write it in that larger space below. Okay, then it says petitioner or the respondent disputes these allegations and the court reserves the findings on these issues pending further investigation or hearing or trial. Okay, so if the other party disputes those, then they can mark, say where the respondent disputes that, the respondent would mark that. You can mark that. The court finds under Family Code Section 3100 that is in the best interest of the children, requires that visitation by, say the respondent, could be the petitioner, whoever it is, must, until further order of the court, be limited to contact supervised by the person set forth in number 6 below, pending further investigation or hearing or trial. In 6 below, we're going to name some people or a professional monitor. But if the court believes and says that there's going to be monitored, then you're going to need to mark the petitioner or the respondent, whoever's going to have monitored visits. You're going to have to mark that. Number 3, this is where we list the children that are going to be, that the visits are going to be monitored for. So you list the child's name and birth date, age, and male or female, and list it for all the children here. Then, number 4 specifies whether it's a supervised visit, the entire visit is supervised, or whether it's just a supervised exchange. So, like mom and dad don't get along, and there's arguments or whatever, or they want to make sure that the children actually get out of one car and go to the other car, then maybe just the exchange will be monitored. But, you know, if that's what's ordered, then you mark it appropriately on this form. 5, supervised visitation provider. Is it going to be a professional or a non-professional? If it's going to be a family member or whatever, obviously that's not a professional monitor. You'll know if they're a professional monitor and they're being paid 30, 40, 50 bucks an hour or whatever it is, obviously that's professional. If it's a family member or somebody like that that's the monitor, then it's non-professional, mark B. Number 6, authorized provider. This is the one where we put the name and address and telephone number of whoever the monitor, or there might be multiple approved monitors. You want to put their information in here. If the parties agree that some other person who's not specifically named in here can be a monitor, and you guys will agree that you may discuss and may be able to agree on a different monitor later, you can mark the box underneath that says any other mutually agreed upon third party as arranged. So that's a handy one to mark down if the parents think they might be able to come up with another person that could be able to monitor the visits. This works well for both sides. One, it works well for the party that needs a monitor because they might lose the other monitor or can't afford the professional monitor anymore, so they need somebody else to come in and monitor the visits or the exchanges. It also benefits the party who does, who's delivering the children for the monitored visits, because what if they can't afford, the other party can't afford the professional anymore, and you don't have anybody else named? You're going to end up going back to court to figure this out. So if you mark any other mutually agreed upon third party that can be arranged, understand that you've got control. You are going to have the right to say, I agree or I don't agree to this person we come up with. So you still have control. So you can mark that box, and it may save you another trip to court or more fighting or missed visits or whatever. All right, duration and frequency of the visits. This applies, they have a note here that says CFL 341 for specifics for visitation. So that's true. You can just put in here, you can leave this blank if the monitor visits and the specific visitation schedule is spelled out on your FL 341, which by the way, there's another video for the FL 341. If it's all spelled out on that video, you can just leave this blank because it is in fact spelled out as it says on the FL 341. 8 speaks of payment responsibility. So if you two are agreeing to, or the court ordered you to split the visitation or the professional monitor fees 50%, then you can mark 50% on petitioner, 50% on respondent, or if the judge ordered something else for somebody other, then you can put that in and fill it out as required. So, but if the judge ordered just the party that requires the monitored visits to pay 100% of the monitor, then it might be, say the respondent is the monitored parent, then you could put 100% in there, okay? However, it's whatever's agreed to or whatever the court ordered, that's what you put in there. 9 says petitioner will contact professional provider or supervised visitation center no later than. So a judge will typically order you to contact the monitor or the professional monitoring company on or before some specific date. So if the judge said contact him within the next 7 days, figure out the date of that 7th day and put that in there and mark that first box. They're probably going to, especially if it's a professional monitor, they're going to order you both to contact them. So the next one is the respondent will contact professional provider or supervised visitation center no later than. It's probably the same date. So if the judge ordered that, or if you guys agreed to that, put that information in there appropriately. And then other parent will contact professional monitor if there's some other parent or that was ordered. Then 10. The court further orders. So if the court ordered some other thing with regard to monitored visits or supervised visits, put it in here. If there wasn't anything else ordered, leave it blank. Then you don't sign this form. This is signed by the judge once it goes into the court. So this is a form that gets typically attached to the rest of the forms that go in with a judgment or an order after hearing or something like that. So this is something that the judge signs. You don't sign it. So once you fill it out, it just gets attached. All right, folks, that was, in fact, the FL 341A supervised visitation form. I hope this video has been helpful. Thank you very much.